You're listening to State of Arrest with me, William Moore. I'm an attorney in South Florida. With me, also a criminal defense attorney in South Florida, William Dorenzo. We also have Chris O'Toole, who's quite proficient in criminal law as it affects his main business, which is personal injury, civil. That's right. A lot of crossover there, isn't there?
There's a lot of crossover.
And what's the main crossover, the main quasi-criminal civil offense, not offense, but action is injunctions, right? Temporary injunctions,
Exactly.
restraining orders.
Yep, exactly. Restraining orders, and there's several types you can get in Florida.
Right. There's domestic violence, repeat violence, stalking, cyber stalking, which is really just a subset of stalking. It's really been expanded over the years.
I know you've dealt with the cyber stalking.
Oh, certainly. That seems to be the main one that's filed upon these days, is cyber stalking with electronic communications and whatnot. A lot of people, however, Bill, and I'm going to direct this to you, a lot of people confuse the criminal act of stalking and basically the inability to have it prosecuted or even policed, and the simplicity of getting a restraining order in the stalking courts or the domestic violence courts, civil injunction courts, I mean.
Yes.
Right.
Well, when you're when you're talking about the criminal world, you're most likely going to have to call the police out, and they're going to at first need probable cause to arrest somebody for stalking or whatever else we're going to be talking about here. And then once they get into the courtroom, the burden is going to go higher beyond and to the exclusion of every reasonable doubt. But when you're talking about an injunction for stalking, the burden goes way down.
Right.
The burden goes way down, and all you need to do to get an injunction is you go in and you fill out some paperwork. The judge will review the paperwork that you filed out, and if you've met that initial burden, there will be a temporary injunction, and then you'll get yourself a final hearing already.
It's the main civil standard of proof, which is what? Preponderance of the evidence, right?
Preponderance of the evidence, more likely than not.
More likely than not, 51%, less than 51%.
Think of the
50
scales of
plus,
justice.
Exactly, just a teeny bit.
Exactly.
And then you come into the judge's biases. You know, I better stamp this looks dangerous, because it can come back to bite a magistrate judge for not granting an immediate temporary injunction.
Err on the side of caution.
They will err on the side of caution because somebody gets killed.
They don't want
their names
face
in the paper because
paper.
they were the only last line of justice to protect this poor individual.
That's right, and the standard is not hard to get that injunction. So to the judge's defense, it's not a heavy decision. I mean,
Right.
err on the side of caution. It lasts for 15 days and it expires. So if you did err on the side of caution, you were wrong. It's a 15-day mistake.
Right, and my experience here in Broward County, Florida, is that the injunction will it'll get extended until you have that final hearing.
If you have a skilled attorney, I mean,
There you go. There you go.
Yeah.
Well put. We were sitting here talking. We decided to do this segment today because first of all, I think is a very misunderstood area of law. You understand it quite well. You understand it quite well, Bill. You understand it, Chris. I just talked to 3 people. I'm talking to 2 people. I didn't mention your name. Chris, I know you understand it well. In fact, we were talking about nuances about this. First of all, it's not understood as it is. This area of law, I see it all the time, even with some of the judges that fill in for our judge that knows it like the back of his hand, Judge Kaplan. He knows these things.
He's amazing.
He's amazing. Yeah. And let me tell you something, cyber stalking, and that could be trying to hurt someone's business. I had a case where this woman, her business was being attacked by a crazy, and it's one thing to raid a business legitimately, but if you're doing it with a malicious purpose, with no legitimate purpose, to harass, to cause significant emotional distress, right?
That's right.
Putting things up on a blog to hurt this individual, we got a restraining order.
Didn't you get that taken down?
And that was the great thing, right? Because not only did we get a restraining order preventing the person from engaging in further conduct designed to harass with no legitimate purpose. I'm using the statute words here, right? Yeah. Cause emotional distress. I mean, your business being attacked and people thinking it's lousy will cause emotional distress. Well, they not only had to stop, the judge ordered upon our request that they go back in a period of time and take down all of these things on the blogs. Thanks, Chris. Right, because it was our position that it was being rebroadcast, and I remember talking to you about this, Bill. Mm-hmm. And ultimately, would you believe it? This person ended up. They took everything down, but they tried to post against my client through a third party. They ultimately went to jail. which was kind of nuts.
That's what happens.
That's what happens,
I'm sure
right?
you had something to do with that.
Well, yeah, I did, but it was easy. It's
Yeah.
easy. This is a real loose area of law when it comes to our Constitution, right? And you've
I've had
got
an
a ton of
example,
money
too.
for someone on the civil side of things.
I actually had a client come to me. She was a very close friend, and she had an issue with her husband. Her husband kicked her out, cut off all her finances. She had no money, and she came to me, I want to file a divorce. I said, well, listen, if we go through divorce, it's going to cost money, this thing. Let's try something. Let's go and file a domestic violence injunction, because her husband was violent.
It was founded.
Yeah, and it was founded. So I had her go and do a temporary restraining order, and we went to a hearing
I
in
remember
15
this.
days.
This is amazing.
And I asked Judge Kaplan to award temporary alimony at a domestic violence restraining hearing.
So, and that's where it's quasi-criminal, quasi-civil. There's no divorce filed,
Quasi-family.
quasi-family, nothing filed. Yet you get temporary alimony.
That's right, because he had shut her out of the bank account too, and that's not fair because the kids couldn't eat. So the judge made him put money into a bank account, and then when we came back, he had to prove he deposited in the
That's
bank
far
account.
out. That's crazy, right?
Oh yeah, that's great.
Yeah, that's nicely done.
Yeah.
It's just exactly. It was important to do because it was the right thing to do.
Yeah,
And
we've
I-
had some crazy ones, Bill. Ones that we can't really talk about for attorney-client privilege, but really some real good times with this area of law.
You know what? All of them seem to turn crazy because one person and the other person is like, "Oh my God, that's not true," and they're just kind of going at each other.
Yeah, totally. It's a Wild West.
I was
but-
going to say, you know, the one thing about these things, as you said earlier, they're often misunderstood, and people go up and they say, "Oh, you know what? Get a restraining order against him." And it's just, I mean, it's easy to get a restraining order, but you can't. Oh, he did A, B, C, or D. Let's get a restraining order.
And you've got to file under the right statute.
Yes.
So many of these things get bounced because it's repeat violence as opposed to stalking.
Yes.
Or it's not domestic violence. It's
Yes, that's right.
It's nuts. You get them bounced.
Any
got
little
it.
error, the clerk will bounce
Yeah.
you, and that's why it's important to hire a skilled attorney to get this done for you.
Right, don't just go down there and
That's
stand
right.
and wait forever. Although you can do the first part. Some people do the first part.
That's fine.
Because it does save you some attorney's fees because filing that petition correctly. If you've got the allegations, go down to the courthouse on your own. If it's close, hire an attorney to draft it for you.
And it's important to know you can get it filed for free. You know?
Yeah.
And then within an hour, the clerk will get you an answer.
Yeah, they move pretty quick.
Yeah, it's very quick.
Yeah. Guys, thank you so much.
You're welcome.
Look forward to seeing you both again.
Thank you.
Take care. You've been listening to State of Arrest. I'm attorney William Moore in South Florida. Joining me today, William Dorenzo and Chris O'Toole. Until next time.